What are the compliance issues that you should be aware of, and what's coming down the pike legislatively? We'll find out on this episode of ShiftShapers.
Change either energizes or paralyzes. The choice is yours. This is the ShiftShapers podcast, bringing the employee benefits industry interviews with individuals and companies who are shaping the industry shifts. And now, here's your host, David Saltzman.
And to help us answer that question, we have invited NABIP Legislative Vice Chair and CEO of MZQ Consulting, ERISA attorney, Jennifer Berman. Welcome, Jen.
Thanks. Thank you for having me.
It's totally our pleasure. So let's dig right in and let's start with one of the big daddies. Let's talk about mental health parity. Why, where, who, and how do you get there?
Oh, that's a lot of good questions. So let's start with the why. So this is really about trying to make sure that health plans are providing mental health and substance use disorder benefits in parity with, or kind of basically somewhat equal to, the medical and surgical benefits that are offered under that plan. Now, obviously, these are not the same things, apples and oranges, or however we want to discuss it. But the way that the rules are designed is to say that in 6 different categories, and those are inpatient and outpatient, in and out of network, and then prescription drug and emergency care, we want to look at medical and surgical benefits against mental health and substance use disorder benefits and make sure that what's being offered are comparable to one another. And when we do that, we're doing it across 2 paradigms. The first is called quantitative treatment limitations. That's things like co-pays, co-insurance, deductibles. And the second is non-quantitative treatment limitations. And those are really anything that is a barrier to access to care other than those quantitative ones. So think prior authorization, but also think formulary design, or even how a network goes about credentialing physicians. There's all sorts of ways that you could restrict access to care through a health plan that aren't just those numerical pieces. So when we sit down and we look at this big picture mental health parity thing, the next important thing to know is that this is not new law. So everything I just talked about is old law. In my world, it's like ancient history. It's over a decade old. So why is there so much talk about this now? And that's because the law changed in December of 2020 with the CAA of 2021 and what I call the congressionally mandated book report. So it's kind of an interesting thing. Basically, what Congress said is, we don't think that health plans are complying with mental health parity. And newsflash, they were not. And our biggest concern is the NQTLs, the non-quantitative stuff. Although I'll tell you, David, they were also not complying with the QTL stuff. But Congress was focused on the non-quantitative stuff. And they said every health plan now needs to do an analysis demonstrating how they are complying. You can sort of see how this exercise works from a policy perspective, right? So go and document how it is that you're complying. And the goal behind that was that documentation process would lead to more compliance. So that's really big picture what this is all about.
Is there an annual reporting requirement?
So the reporting requirement is not technically annual in nature. The requirement is that these NQTL analyses be maintained, that they be up to date and accurate, and that they be available to both the Department of Labor and participants upon request. And so because plans change annually, because the current operational data changes annually, we do recommend that these be maintained on an annual basis. But the law does not say annual specifically. And I think that's something that certainly the Department of Labor and the regulators are grappling with as they're trying to figure out sort of exactly how to go about doing this.
Well, and correct me if I'm wrong, but isn't this just something that you have to have on hand as a plan or an employer? It's not something that you actually send to the government every year, is it?
That's correct. We don't actually send it to the government, but you do have to have it on hand. There's a fiduciary obligation to have it. And it's also available not just if the government asks for it, but I mentioned this already, it's available if a participant asks for it. And in my world, That means it's available if a plaintiff's attorney asks for it. So, the question I get, the unasked question, is what's going to happen to me if I don't do this? There is certainly risk that the DOL will come after you. I don't want to say that there's not, because this is actually the DOL's number one enforcement priority. So it's real from the DOL. But there is as much, if not more, risk that a plaintiff's attorney or a participant might come after a plan for not having what they need to have in place.
Now, these are fairly extensive. I know that some folks I've spoken to recently have kind of been surprised at what compliance firms charge for doing this kind of work. But it's not just a simple fill in the blanks form, is it?
No, it's a very, very extensive exercise where in each NQTL that we talked about, so for every plan that you look at, there could be anywhere from 15 to 30 of these things. And for every single one of them, we have to look in each of those 6 buckets that I mentioned and look at how the plan is designed in writing across a number of paradigms, and then how it's working in operations, look at actual operational data. So there are numbers involved. It's not just non-quantitative. And look at, is the plan in compliance? So it is a very extensive exercise.
Well, and isn't the government actually looking into whether the government is doing enough? Isn't there an inspector general who's out, kind of looking under rocks and things now?
There is. So the Office of Inspector General is in fact investigating the Department of Labor to see if they are doing enough to enforce this law.
And in the middle of all of this, last fall, there was almost 400 pages of proposed regulations. What about those? And when, if ever, might we see those? And what were the kind of comments about?
Yeah. So first off, they're mind-blowing. They're overwhelming even to me, and this is what I do for a living every day. There were over 10,000 comments submitted, so there's a lot there. They make it even more complicated than it already is. So this is not a, everybody's failing the report so nobody can do this sort of response from the DOL. This is we're making it harder proposal. And then, when are we going to get the final rule? Anybody's guess. I don't have a crystal ball, but what I will say is the Department of Labor does not have an extensive, massive staff, and they do have a legal obligation to review all of the comments that were submitted. Over 10,000 comments were submitted. So I am not holding my breath or expecting these proposed regs to become finalized anytime soon. That being said, there are final rules already in existence, and there's a statute in existence. So I've heard many say, we're going to wait for the final rule. There's no waiting for the final rule for this law to become effective. The law is effective, and plans that don't have this are out of compliance today.
So let's move on to another subject, because there's a deadline coming up early this summer on RxDC. What is RxDC all about, and what do folks need to know?
Well, it's mandatory reporting in the District of Columbia. No, it has nothing to do with the District of Columbia, but some people ask that. So RxDC stands for Prescription Drug Data Collection, and it's another CAA 21 requirement. If ever you wonder why we keep naming the year of the CAA, there are lots of CAAs. CAA stands for Consolidated Appropriations Act, and so there are many. So the 2021 one is the most interesting to benefits attorneys. So it's another CAA requirement, RxDC. And what it is all about is that the government wants to evaluate and understand sort of the finances of health plans. And it's not just the employer-sponsored world, although I'm most focused in what I do every day on the employer-sponsored world. So they want to know sort of all of the money flowing into that system, and then all of the money flowing out of the system, both for medical claims as well as for prescription drug claims. And the name of the project is Prescription Drug Data Collection. There's a lot of very detailed prescription drug information, but there is also information about the money coming in again and the money going out to medical claims. So it's a pretty complex set of information that CMS is looking to collect. And the reason for that collection is so that they can complete studies and explain to Congress where the money is going in our health system.
And there's a whole bunch of different reports, starting with D1 through 9?
D1 through 8, yeah. D1 through 8. And then there's the P reports. So the P reports just tell you who you're reporting on. That's the identifying reports. And then the real content and the meat of this is in the D1 through 8 reports. I like to break them up into 3 chunks. D1 is the information about stuff going into the plan. How much money went into the plan, broken down between sort of total dollars. So think insured premium dollars or fully insured equivalents for a self-funded plan. And then when you look at that dollars, they want to understand how much of this was employer dollars versus how much was employee dollars and how many people got covered. So that's what D1 is all about. D2 is medical claims. Where did the money go from a medical perspective? And then D3 through 8 is a whole bunch of detailed information about where the money went on prescription drugs.
Are carriers and TPAs doing this for clients?
Yes and no. And that no part is the real key to this. So D3 through 8, the prescription drug piece, pretty much being taken care of for the vast majority of plans. So whether you're fully insured, self-funded, in most cases, whoever is responsible for administering that pharmacy benefit is taking care of it. Then we've got D2, so moving backwards now, that's the information on the medical claims. And that is typically being reported by whomever is administering those medical claims. So fully insured plans, again, it's your carrier. Self-funded plans, TPAs are typically taking that on. D1 is the hard piece to this, and that's because it's enrollment data. It's also cost data broken down between employee and employer dollars. That's where things get tricky because that's not information that carriers, TPAs, and PBMs typically have. And so the real key is for plan sponsors, who are the ones who are ultimately legally liable for this, to make sure that the D1 is happening, the D2 is happening, and the D3 through 8 is happening. So are all 3 of these pieces happening? And then for extra bonus credit, anybody who really wants to be super, super astute about this, there's aggregation rules as to what level this can be reported at. That gets super complicated, but suffice to say that there has to be coordination between TPAs and PBMs as to how the D2 and the D3 through 8 piece work. If you're doing it at the plan level, and most employers are relative to their D1 piece, you don't have to worry about it. But when you start rolling plans up and you can do some level of coordination, it gets even thornier.
So if you are a mere mortal, we're just 2 subjects into what we're talking about, and your eyes are glazing over. But wait, there's more, as they say. We don't typically start thinking about ACA reporting until later in the year, but there have been some changes, and people need to be aware of them because they're pretty pervasive. What's happened on those?
So a couple of points here, although now you've got me scared that nobody wants to talk to me. But okay, continue.
Everybody wants to talk to you.
Well, thank you. Thank you for that. Big points. Just a reminder, I can't remind people of this enough. ACA affordability thresholds have plummeted in 2024. So the percentage is now well below 9% for coverage to be considered affordable, to avoid that 4980HB penalty, which is now more than $4,000 per year. So please, please, please watch that number carefully when you are designing your plans and designing your premiums, the lowest cost employee only premium, to make sure that if it's not your intention to offer unaffordable coverage, you are not accidentally offering unaffordable coverage. That is a big one to be aware of in the ACA reporting world. Next big one in the ACA reporting world and trap for the unwary, electronic filing requirements. Until this year, the reporting that is due this spring for the 2023 calendar year, employers who were under 250 returns, filing less than 250 1095s, 1095Bs or 1095Cs, had the option to file those on paper. So they could print them out from any number of different sources or, opportunities, do them themselves, fill them out by hand, use a computer software and print it, and mail it to the IRS. That is no longer an option. Electronic filing is now required unless you are filing fewer than 10 forms. And so you need to make sure that any system you are using to help with your ACA reporting is going to do the e-filing component for you. Unless you are filing less than 10, it requires you to be a self-funded plan with fewer than 10 people on the plan, which is a very, 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 very small minority of plans. So almost almost everyone with an ACA reporting obligation at this point has to do it electronically.
Fun and games.
And the last fun and game of the ACA world is just to say that IRS enforcement of penalties related to both the employer mandate as well as filing penalties, late penalties, incorrect penalties, is at an all-time high. It's something that I see and deal with almost every day. So just be cognizant, be careful. We no longer live in a world of good faith reporting, which means you've got to get your 1094s and 1095s right. You can't just go to the IRS and say, I'm sorry, I did my best. That rule is gone. And so, it's something to focus on and make sure you're getting right, not just getting done.
What do you do if you're an employer and you, heaven forbid, didn't file last year's or the year before? What if you're in arrears and you want to just get caught up and get to good standing?
Find a reporting partner who has the ability to do prior year filings. It is absolutely possible that late filing can trigger some late filing penalties. However, they can be relatively easily remediated and negotiated down. The penalties for late filings and failure to file are they're nearing $600 per form at this point. You don't want to go there.
So get yourself caught up if you're not.
Get yourself caught up if you're not. And by the way, there's not a week that goes by that I don't get a letter in from a client somewhere that has just never filed and is being actively penalized. So there is an active IRS enforcement regime happening here.
And that's something that everybody who's listening should be aware of and should be talking to their clients about if they haven't already. I'd like to think that all of our listeners are astute enough so that they've had these conversations, but if you haven't, now's the time. So
if you had them 5 years ago.
Correct.
Correct. Yeah.
Absolutely. So let's move on to the thing that maybe made the least amount of sense last year, at least to me, which is gag clause attestation. What is it? Why was it such a bear to do? And why did parts of it not really make any sense?
So the gag clause attestation stems from a CAA requirement that health plans cannot have gag clauses in their contracts with their service providers. So a gag clause is a provision restricting the plan's access, the plan or participant's access to cost and quality information. So when the plan participants and the plan sponsor need to have access to information about what they're paying towards claims and quality information about providers, and they can't contract out of that information, say through a confidentiality clause or something like that. So those clauses in contracts are now not legal under the CAA. Step 2 of this is the CAA didn't just say gag clauses are illegal. It also said, and therefore, plan sponsors must go and attest to CMS that they have no gag clauses in any of their contracts, both direct contracts and indirect contracts. So an indirect contract is one that the plan sponsor might not be a party to. They might have a contract, say, with a third-party administrator, and then that third-party administrator might have a contract with somebody else, and they're worried about if there are gag clauses there. It becomes very hard to know and make a federal attestation to the presence of language being in or not being in a contract that you're not even a direct party to. So that's one issue. But a bigger issue is what exactly is a gag clause? And many of the provisions that we find when we sit down and we actually read these contracts between plans and their sponsor and their carriers or TPAs is that there is language that restricts access or restricts business associates access or could qualify as a gag clause. And so then that puts these plan fiduciaries in the position of having to decide, well, it's not legal for me to have this provision in my contract, but it's there. And I have a legal obligation to go tell CMS that it's not there, but it is there. So what do I do?
What indeed?
Yeah, you want me to answer you were going to ask me to answer the question. So I spent months trying to decide the answer to that question. The first answer is we don't lie to the federal government. Okay, so filing an attestation that says that there is no gag clause when there is in fact a gag clause is not a good idea. So the next step is beginning to work with and actively getting rid of those gag clauses and working with those vendors to find a way to eliminate them. And ultimately, over time, if it becomes impossible to eliminate them, then there is a decision that needs to be made in their fiduciary capacity as a plan fiduciary as to whether or not it's appropriate to maintain a relationship with a vendor who's not willing to take illegal provisions out of a contract. And so it's a documentation and a process question, but it's also a question of, a legislative policy that is now the law, and now it has an enforcement mechanism behind it that is attempting to change the industry and change how things are done.
But the software that was required to be used for the federal government's software for reporting didn't give a lot of room for, gee, we did our best, or we tried, or we're not sure, or whatever. And attestation, you're the lawyer on the call, but attestation is an actual thing. And they didn't just say, make your best efforts, let us know. They said, you're going to attest. What are employers and plans to do?
Well, I am not here to provide legal advice or counsel, and I should have read a disclaimer at the beginning of the call on that point. So this is worth exactly how much money you paid for me to be here and talk to you about this. And it is not supposed to be deemed as legal advice. But again, you cannot attest to something that you do not know to be true.
So what do you do?
You need to make sure that you're working actively to get rid of those provisions.
Yeah,
and documenting your process.
It's a big job, and it's I think the intent was great, but the actual implementation was challenging, especially for plans and employers that might not even have those contracts or have access to those contracts. So it'll be interesting to see how that shakes up and what happens going forward. Let's move to something that I don't think a lot of people have heard about, which is FinCEN. What is FinCEN? It's FINCEN. What is it? Why does it matter? And who's got to do what?
So FinCEN is the next big reporting requirement coming down the pike. It is actually a Department of Treasury requirement. It does not relate directly to benefit plans, but I think all of us in the legal and accounting community are taking up the mantle of making sure that we inform folks about this, because this is a big one. It has criminal penalties associated with it, and significant financial penalties. And it is essentially a registration requirement. It's a registration of ownership that has to be filed with the Department of Treasury, specifically FinCEN, which is a new department created for this purpose, to tell them who owns what. And when I say who owns what, I mean who owns what. So almost the vast majority of companies in the country are subject to this. Holding companies, operating companies, not nonprofits, and not large entities with more than 20 employees and more than $5 million in annual revenue. And then there's some exceptions for certain financial services organizations. Pretty much everybody else is subject to this. And what they have to do is they have to go to FinCEN or work with a vendor partner to register who their beneficial owners are. And beneficial owners include people who actually own the company, more than 25% of it, but also key decision makers within the company. So the C-suite and the people who control the C-suite, the board. And those folks have to be registered with FinCEN, with the Department of Treasury. And then those registrations have to be maintained and kept current. And it's, who you are, where you live, driver's license or passport number. So, it's, name, rank, and serial number for every company, except for those exceptions. But it's a big, big project. And as recently as this morning, I heard, statements from the Department of Treasury about their plans around it. And while they're not meaning to be punitive with those, that penalty authority and the criminal penalties and dollar authority, they're very, very serious about enforcing this registration requirement.
Well, and they're pretty clear and open and honest about it on the website. They say that the reason they're doing this is because they want to make sure that they have all their ducks in a row. If they find any RICO activity, racketeering and corrupt organizations activity, or they need to go after somebody.
Yep.
And
they don't know who owns what. Everybody's all the companies are registered with the states, and even those registrations don't have enough information in them. I mean, and the exceptions to these, the rules are thorny, and it's like, well, if the owner is less than 18, then the mom can do it for them. But there's not a lot of exceptions here.
What's
really
interesting, as we've talked to people, is that there are attorneys and there are CPAs and financial planners and other people who aren't even aware of this yet.
It's true. And the deadlines are coming up fast. So every single entity in the country that existed before this year has to be registered that's subject to this by the end of this year. And then the new companies have 90 days from their registration. So it's real, it's here, and it is happening.
And if there's a change in ownership, that also needs to be updated, yes?
Yep. And not just changes in ownership, because, and this is one of those thorny things. We call it beneficial ownership reporting. But again, it's not just about ownership, it's about those key decision makers. So CEOs, CFOs, COOs, they're considered beneficial owners too under this very broad definition.
So let's make the small leap from there to something you're starting to talk, I know, an awful lot about, and that's fiduciary responsibility. And if indeed it needed any rocket fuel underneath the conversation, recent events at Johnson & Johnson, which you'll talk about, have kind of started the afterburners on that, haven't they?
We live in interesting times, don't
Indeed.
we? Indeed. So Johnson & Johnson was the case we've all been waiting for, or the case we've all been dreading, or certainly something that those of us in the ERISA bar have been anticipating for a long time. So this is a case where the fiduciaries of a health and welfare plan were named directly in a lawsuit for breach of fiduciary duty. And it was just filed in the first week of February here, the first full week of February 2024, against J&J and its fiduciaries for failure to exercise the duty of prudence. Basically, they said you didn't act like a good fiduciary when you were administering this plan. And the biggest claim circles around the cost of prescription drugs under the plan. And the big marquee example in the case, although there are others named, is an MS drug that the plan paid over $10,000 for a 90-day supply of this generic drug that was available retail for $70 to $80. Wow. And as low in some cases as $30. So we're talking, just massive disparity. And the PBM is named in the case, the broker is named in the case, and the plan fiduciary committee, and J&J did have a fiduciary committee, which is a step ahead of many, many health and welfare plans that I work with. Every single member of the fiduciary committee was named, and the three top members of the fiduciary committee, the CHRO of J&J and their two VPs, were named specifically. Their names are in the case.
It's pretty amazing. And this came from inside J&J. This was somebody who was on the J&J plan.
And still is. Uh-huh. They're technically currently employed by J&J. Oh.
Wow. So what means this in a broader context?
This is a huge wake-up call to the entire employer plan community and reminder that ERISA is still here. And that all of these plans, we talk about the CAA, we talk about the Affordable Care Act, we talk about a lot of law that governs health and welfare plans. But the biggest, the big kahuna of them all is ERISA, which says employer plan sponsors are always a fiduciary, and they have a heightened duty with respect to the administration of that plan. And we forget that in the midst of things, that folks who are running health plans have to act in the best interest of the participants and beneficiaries always. And they have to demonstrate a process and procedure that they have gone through in doing that. And there is a massive disconnect today between how that is done in the retirement plan world, where we are making decisions about people's money, and the health and welfare plan world, where we're making decisions about people's lives. And that's this wake-up call about the need to change that.
So let me ask the question that's probably on a lot of people's minds, which is, how would the folks who are running this plan, these three fiduciaries, how would they have known what the cost of that drug was?
So asking questions, really understanding how that formulary worked, how the relationship with the PBM in that case worked, making sure that the advisors that they had. So there's no expectation that as a plan fiduciary, you become an expert in everything that there is to do in administering a plan. The law completely contemplates that, the average fiduciary can't do everything. But what it says is that fiduciary is going to go through a process and make sure that they have advisors in place who are counseling them on those things. So the questions that I would have asked if I were part of that process were, has this fiduciary committee hired the correct consultants who understand how the pharmacy industry works? And are they telling them, to ask the right questions? Are they going through a comparative benchmarking process where they're looking at the cost of drugs and seeing, it wasn't just this one example in the case. They give, the case names a litany of other drugs where this same pattern and practice is seen in the way that the J&J health plan was administered. And so the way that I would assume that J&J is going to try to defend this case is going to be to show that there was a pattern or practice of making good decisions that are documented there. And that even despite that, this was the result, and here's why. And that might be a successful defense, we'll see. But in any case, the way to protect and the entire concept of fiduciary duty is that you're going through a process, that you're looking at benchmarks, and that you're acting as a reasonable person of like capability would under the circumstances. So it's a heightened standard. This is not just negligence. This is, you have a higher standard and a higher duty to really understand what you're doing.
If you're an advisor out there in the universe, should bringing these professionals to the fiduciaries be something that you engage in, or at least discuss or encourage? Because
Absolutely.
as you said, the broker's named in this thing, so you want to stay out of court. What should you do as an advisor?
Absolutely. This is, again, something where advisors need to have the right partnerships and be at the right table. And I think so many advisors have this automatic visceral reaction. I don't want to be involved with anybody who's going to evaluate me or talk about me and my comp and if I'm doing a good job. And by the way, any fiduciary advisor or somebody who's coming in and working with a fiduciary committee is going to put vendor evaluation, including the evaluation of the broker, on that list. And broker comp and the compensation of every vendor is going to go. Reasonable compensation is a fiduciary responsibility. They have to monitor that. So straight up, anybody who comes in to talk to you about fiduciary duty is going to talk about if you, as the advisor, are doing your job. So thing number one, if you're doing your job, that should not scare you.
And go to thing number two.
Go to thing number two. Okay, fine. I can't help myself. But thing number two is that is how you protect your plan, is by going through the motions and documenting it and really saying, yes, we've evaluated these things. Compensation does meet benchmarks. The amounts being paid out do meet benchmarks. And here's how we are showing those things, right? There's nothing to be afraid of here. It's process, it's procedure. And that's how you demonstrate that you've in fact met these compliance obligations. And by the way, along the way, you're going to find that you were wrong and that there are things that you're going to find that you didn't anticipate finding. And that's okay too. I used to say there's no ERISA jail. There is, but only very, very, very bad people go to ERISA jail. Most of the time, when you find a mistake, you know better, and then you do better. And that's what the process is designed for.
Oh my. Well, now that we've had a romp down compliance lane, let's turn to the legislative side of the equation, because there's always something going on in Washington, and there are a few things that advisors need to keep their eye on, first of which would probably be the employer reporting bill. What's in that? What does it mean? What are its chances of passing? How will it affect things? Employer
reporting bill, super high likelihood of passing, hopefully when they keep the federal government open at the beginning of March. It's great and wonderful and will be very exciting when it passes. It will not change very much. Employer reporting is here to stay. This is still ACA reporting we're talking about. It's going to fix some of the biggest problems with ACA reporting. Allow for birth dates to be used sometimes when SSNs aren't available, allow for a little bit more electronic distribution, give a little bit more time to respond to employer mandate penalties. And those are all good things. It is not the once upon a time version of the employer reporting bill that did things like allowing for prospective reporting or eliminating ACA reporting. That is long ago off the table. And so this employer reporting bill does make some nice substantive improvements, but it is nothing that's going to change the game or really make it substantively a super different process than what it is today.
So another thing that's floating around in DC, which somebody once described as 20 square miles surrounded by reality, is the lower cost, more transparency bill. Not exactly a title that rolls off the tongue, but what's that all about?
So that one does a few things. Most significantly, it codifies a lot of the regulations that we have around transparency. So there was a set of regulations at the end of the Trump administration. Then there's some legislative stuff in the CAA. And so a lot of that is in that bill. And then there are some additional provisions there around something we call site neutral, which is making sure that when the same provider or provider group, really hospitals and things like that, owns both inpatient and outpatient facilities, that you pay the same amount for certain things, whether you're at the inpatient or the outpatient facility. So there's some site neutral legislation as part of that bill, specifically as it relates to certain Medicare administration, though, and we would like to see that spread further into the employer plan world and stuff like that. So there's a few, additional transparency related pieces to this, but a lot of it really is codifying existing law, existing regulations, and then making them statute.
So things to watch for, but not to be concerned about. Now, there's a whole bunch of PBM legislation floating around too. What's that all about?
Whew. Well, that is a topic for another session and another day. And I know you've got plans to bring in some folks from the PBM world who will do a far better job explaining what is going on in the PBM world than me. Suffice to say, here's what I will say. There's a lot of need for legislation and reform probably in the PBM business. J&J case being an excellent explanation of how things get a little bit wonky and sideways in the prescription drug world. And then what we have happening is, because the federal government has not done a lot of this, we're seeing lots of states start to do this. And so now we have very interesting Supreme Court legislation. Supreme Court legislation. The Supreme Court theoretically does not legislate, according to the Constitution. Now, I will leave it to you to decide if they actually do or don't legislate. Supreme Court decisions about whether or not state governments can regulate these PBMs in ERISA plans, because ERISA preempts state law, blah, 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 blah. So it's a very, very interesting world. And we have states trying to get in on the act because the federal government hasn't done it yet. Then you have a lot of federal rules. It's all fascinating. There's no question in most people's minds that there is a need for pharmacy legislation. And we have a little bit of a push and pull until we get something federal. We're seeing it at the state level. That's causing a lot of tension in the ERISA world. It's a big old mess and could be another hour. But I will spare you, because if they've stuck with me this long, they're already should be up for safe.
I mean, I guess the question is, given the amount of money that Big Pharma has to throw around on the Hill, are we actually going to see anything, A, in an election year, and B, even thereafter, that's substantive?
So there is a lot of money from Big Pharma, right? And so, but sometimes the need gets so big that it outweighs even the most powerful of lobbies. And, I don't know about you, but, I certainly have that experience every couple months where I'm standing in the pharmacy and dealing with a copay card and trying to figure it all out. And, there's so many stories and so much need and so much happening that I would not be surprised to see some level of PBM legislation passed. The question is if it's going to have any teeth and which piece is going to be. So my guess is yes, you will see something with the letters PBM in it. Federally, how much teeth that's going to have.
Yeah, but it does seem that with PBMs, we've gotten to the point where we're standing on the corner of anything goes meets enough already.
It's an interesting place to be.
It is. Last thing to talk about, telehealth relief. Why does telehealth need relief? What's that all about?
Why does telehealth need relief? Telehealth needs relief because, and this is all virtual care. It's not just telehealth. I'm reminded that most of it is not on the telephone anymore. But because of HSAs and high deductible health plans. So you might recall that in order to participate in an HSA, you cannot have disqualifying non-high deductible health plan coverage. which basically means you have to hit your deductible before anything can be covered under your health plan. During COVID, that rule got suspended specifically with respect to virtual care or telehealth. And there had been before that a whole lot of conversation about, well, can we provide free telehealth to people before they hit their deductible, because we want to encourage that behavior. And then that rule got extended a couple of times. There was a gap. It was very complicated and very difficult for all of us compliance people. Today, that extension runs out at the end of 2024. So under current law, you can in fact have access to virtual care before you hit your deductible and remain qualified for an HSA. But that will revert back to the old law on January 1st, 2025, unless there's legislative action to change it. So, kind of in that boring but not at all boring category of things that really will impact people if they don't get changed.
Not that that's not enough, but is there anything else on the radar that we should be looking for?
Oh, well, there's always something, and you never know what's happening next. But I think we probably have covered enough territory for today.
Well, and we're grateful for your time. NABIP Legislative Vice Chair and CEO at MZQ Consulting, ERISA attorney Jen Berman. Jen, thanks so much for sharing your expertise.
Thank you.
Shout out to the crew at Grand River Agency for their awesome post-production. This ShiftShapers podcast is copyrighted content and may not be reproduced in whole or in part without the express written permission of ShiftShapers Solutions, LLC. Copyright 2024.